Martial law. Martial law involves the temporary replacement of civilian rule by military authority and is usually called during wars, rebellions, or natural disasters. If martial law is enforced, the territorial or national military commander has unlimited power to enact and enforce the law. Martial law is justified when a civil unit is suspended, completely absent, or invalidated. In addition, martial law invalidates all existing laws, as well as proper control of civil power and judiciary. The power of martial law was once thought to be almost absolute, but it has its limits. For example, while a civil court is functioning, civilians cannot be brought to justice in a military court. Nevertheless, the military commander's authority to make court decisions under martial law is virtually unlimited. Martial law has been imposed 9 times since World War II, and in 5 cases, it was aimed at stopping opposition to the Southern Federal Separation Order. Pentagon officials have always had a trend of mutual aid between the military and civilian law enforcement agency and should continue, but their ability to enforce civilian law is limited. Military personnel shall not be used for surveillance or undercover investigations and shall not use as informants, investigators, or cross-examiners unless the investigation is a joint military and civilian operation interested in the outcome of the case. After the declaration and imposition of martial law, citizens would still go on to challenge the constitutionality of Proclamation number 1081. Those arrested filed petition for habeas corpus with the Supreme Court, but Marcos, who had originally announced that martial law would not supersede the 1935 Constitution, engineered the replacement of the Constitution with a new one. On March 31, 1973, the Supreme Court issued its final decision in Abellano v. Executive Secretary, which essentially validated the 1973 Constitution. This would be the final legitimizing decision on the constitutionality of martial law. September 17, 1974, the Supreme Court dismissed petitions for habeas corpus by ruling that martial law was a political question beyond the jurisdiction of the court, and that, furthermore, the court had already deemed the 1973 Constitution in full force and effect, replacing the 1935 Constitution. That's all.
Good day everyone. This is my report, Declaration of War. A declaration of war is a formal act by which one state announces existing or impending war activity against another. The declaration is performative speech act by an authorized party of a national government in order to create state of war between two or more states. The legality of who is competent to declare war varies between nations and forms of government. In many nations, that power is given to the head of state or sovereign. In other cases, something short of a full declaration of war, such as a letter of marque or a covert operation, may authorize warlike acts by privateers or mercenaries. The official international protocol for declaring war was defined in the Hague Convention of 1907 on the opening of hostilities. In the First Hague Convention of 1899, the signatory states agreed that at least one other nation be used to mediate disputes between states before engaging in hostilities. The Hague Convention of 1907, called Convention Relative to the Opening of Hostilities, gives the international actions a country should perform when opening hostilities. Few nations have formally declared war upon another since then. In addition to this, non-state or terrorist organizations may claim to or be described as declaring war when engaging in violent acts. These declarations may have no legal standing in themselves, but they may still act as a call to arms for supporters of these organizations.
Clemency. Clemency is the definition and legal term across the globe. Clemency legal definition may vary, however, the basis of intention remain the same. Clemency is not the right, it's a privilege. It's come typically as the result of religious waiting a petition. Also, giving someone clemency does not mean the crime was forgotten or that the perpetrator is innocent of the crime. Rather, it's an act to typically acknowledge the perpetrator has been taken responsibility for the offense. In the same way, it also signifies that some type of relief is made of punish that the heir face of about to face. Parole, also known as a provisional release of supervised release, is a form of early release of a prison inmate where the prisoner agrees to abide by the certain behavioral condition, including the checking in with their designated parole officer, or else they may be arrested and returned into the prison. A parole officer with the Missouri Department of Correction interviews a drug-related offense probationer organizing for the French word parole speech spoken word, but also promise the term became associated during the Middle Ages with the release of prisoners who gave their words the difference greater for pardon, amendment, or communication of sentence in the parole are still considered to be serving their sentence and may be returned to the prison if they violate the condition of their parole.